Hello, my name is Charles Goldstein. I've been a practicing attorney for 50 years. I regularly advise and litigate only on behalf of employers in the private and public sector. As an advisor who routinely litigates in the field of employment, wage and hour, and labor law, I have a unique point of view about new employment, wage and hour, and labor laws that stream each year out of the California legislature and how they actually work in practice in the workplace. Over my 50-year career, I've represented both public and private sector employers throughout California. My unique perspective has been gained by 50 years of experience dealing on a daily basis with real-world employment, wage and hour, and labor problems. In the private sector, I represent many employers in a broad cross-section of industries, including food processing, construction, metal fabricating, chemical distribution, logistics, retail sales, wine, beer, alcohol distribution, hospitality industry, restaurants, insurance and financial services, healthcare products, transportation, private schools, nonprofit associations, and many other industries. In the public sector, I've been advisor to many California cities, counties, and special districts. I've also advised the superior courts and represented the County of Los Angeles in many high-profile cases. I was the lead attorney for the city of Glendale in the landmark case of Loader versus the city of Glendale. That case legalized employers' right to drug test job applicants. As special labor counsel to the South Coast, Southern California Rapid Transit District, now the Metropolitan Rail District, I negotiated the landmark work continuation and labor stabilization agreement that barred strikes for the duration of the construction on the $3.5 billion project. I've spoken to associations across the country, over 1,000 different associations. 50 years is a very long time. It's half a century. So when I give advice to clients, they listen because they know it's based on reality, not what I see in the law itself, but what I've seen experienced by employers. The legislature passed two laws that I want to discuss. One, the mandatory paid sick leave law, and a second requiring training that up to this date was for sexual harassment prevention to include training for bullying. Mandatory paid sick leave law, AB 1522, enacted by the legislature as the Healthy Workplace, Healthy Families Act of 2014, takes effect on and after July 1st, 2015. The new law states that any California employee who works 30 days or more in the commencement of a year will be entitled to accrue paid sick leave no less than 1 hour for every 30 hours worked, up to a maximum of 3 days per year. Now, what can employees use the sick leave for? Do employees have to notify their employer in advance of using the sick leave? Well, frankly, those topics were not covered in the new law, and that's a problem, because what was covered is the fact that an employer who retaliates against an employee who uses paid sick leave can be fined severely, and if they fire the employee can gain reinstatement back pay. There are no restrictive provisions in the new law that require the employee, for instance, to supply proof that they actually use the leave for the illness of themselves or their family. Not only that, the definition of what the leave can be used for is so broad, it includes Potentially, if somebody claims to be a victim of domestic violence, a very serious issue, or sexual assault, it's just so broad, there are no limits. And that's a problem, because when you as an employer are trying to adequately staff and somebody doesn't show up, or they decide to take their leave day on a day you don't have other staff, that creates serious problems. We're going to have to wait and see how cases develop to determine whether employers can put in place any restrictions, reasonable restrictions, on the use of mandatory paid sick leave. Now, one thing about the mandatory paid sick leave, unlike vacation, that in California you must pay the employee upon their termination, mandatory paid sick leave under this law is not payable upon termination of employment. However, if the employee returns to work within a 12-month period, you have to credit the employee for the accrued sick leave. Not only that, you must keep records. The labor commissioner will look at your records to determine whether you in fact allowed employees to take paid sick leave or accrue paid sick leave. You must keep those records for at least 3 years. So that's a very important clause. There's another thing. Employees are allowed to take their paid sick leave in increments of 2 hours. An employer can require that the employee take their sick leave in an increment at least 2 hours. Now, there are a number of questions that may come up. For instance, if your employees are covered by a labor contract that provides more generous benefits, will they be covered by the paid sick leave law? And the answer is no. If the employees are exempt, for instance, salaried exempt people, administrative, supervisory, professional, are they covered under the new sick leave law? The answer is yes. What the new sick leave law says is that you will divide the salary of an executive, administrative, professional, or other exempt person by 40, and you will get an hourly rate for the accrual of sick leave. I don't think this law was well thought out. I mean, the purpose is laudatory because people do get ill. People need to take time off. This gives them the ability to do that. They have family illnesses. We all understand it. The real problem is not the people who use their paid sick leave for these purposes. The problem are the abusers and how it again limits the ability of management to protect itself from people who abuse the benefit. On the other hand, you have to look at the use of paid sick leave on a case-by-case basis, and that's where it's important to be able to call somebody who's skilled, understands your situation, who can give you good advice. The firm, the Goldstein law firm, does that routinely on a day-to-day basis. Now, the second law I want to discuss is the law that requires supervisory training regarding sexual harassment to now include an anti-bullying provision. What is abusive conduct? This is conduct of an employer or an employee in the workplace with malice that a reasonable person would find hostile, offensive, unrelated to the employer's legitimate business interests. Well, those are very broad terms. Does that mean that if I'm angry and I tell one of my subordinates that they have to follow an order, or I tell one of my subordinates, I don't know why you're in the practice of law, maybe you should be a meat cutter, which is that's an honorable profession, or a milkman like my father is an honorable profession. Is that going to be considered a threat? Or if I tell an employee that they're not doing what I want, it's only whether the comments and the actions are hostile, offensive, unrelated to legitimate business reasons. But we're going to have to develop a training program, every employer in the state that has 50 or more employees, and discuss bullying. Bullying is not the law at this point, but you must train people to avoid bullying. One of the aspects of bullying is undermining somebody. I've been in many cases where somebody said, look, I was doing just fine. And then somebody was giving me poor assignments, somebody was overcritical, and they were undermining me. And I'll say, well, why were they doing that? It's because they were jealous of me. You don't know whether that is going to be a cause of action down the road for bullying, which doesn't exist right now, or a claim. So what I'm going to be doing on a monthly basis is having these video chats with you every month about developments. Not only do we have a newsletter that goes out to our clients and our newsletter readers and people across the country, we're going to put each month on our website a video about new developments that are occurring in employment, labor, wage and hour laws that you ought to be knowledgeable. Thank you.